During your divorce, the judge ordered you to pay alimony to your ex. Now you're not paying it. They're coming after you for those payments. What can the court do to you, and how can they get you to pay? Hi, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all based on your income. What that means is that the less you make, the less you pay. So let's talk about alimony and how to enforce the payment of alimony. So once again, alimony is financial support paid by one ex-spouse to the other ex-spouse. You're obligated to do it. It is a court order. So not doing so is a violation of that order, and you are in violation of the law as far as the court goes. There may be many reasons why you're not paying for alimony, but let's talk about just if you're refusing to pay or if you have no particularly good reason for not paying. So what could happen? Well, a number of things could happen. Um, Most likely, your ex will file a contempt of court motion against you. So contempt of court is basically has to prove that there was an order and that you're willfully not obeying that order. So you contempt motion is filed. You're put on notice that there will be a hearing before a judge on that contempt motion. So the two of you will have to go before the judge, and the moving party, that's the person, your ex, who filed the motion, will go before the court and say, Judge, my ex isn't paying the alimony that you ordered way back when we got divorced. They're behind X amount of dollars, and it's just not coming in. The judge will turn to you and say, "What's going on? Why aren't you paying it? What's happening? Why are you violating my order?" And they take it very seriously, of course. So you have an opportunity to defend yourself and to explain to the judge what's happening. Let's say the judge wants to continue those payments, have you continue those payments. What can he or she do? Well, there are a number of things that the court can order in order to put pressure on you to start paying your alimony. One of them is wage garnishment. What that is if you're working, if you are an employee working for somebody else, so you're a W-2 employee, the court can issue a judgment against you for the past alimony that's due and for any ongoing alimony. They contact the court contacts your employer, and the employer garnishes your wages. So that means they take money out of your paycheck every pay period, put it aside, and give it to the court so that they can give it to your ex. So that's what a wage garnishment is. That's one thing that they can do. Another thing that they can do is there could be a writ of execution. A writ is an old-fashioned legal term. Basically, it's a piece of paper. Also an order, and it's a writ of execution. And so what they're trying to do is they're trying to get any money from you out of any assets that you may own. So a writ of execution can be used to levy your bank account. That means go after money that you have in a checkings or a savings account. They can put a lien on your home if you have that. They can do all sorts of things depending on what assets that you have. Another thing that could be asked for, and the judge could decide to do, is to intercept any tax refunds that you have. So you file your taxes, at the beginning of the year. You're expecting to get X amount of dollars back, but you're behind in your alimony. So the court can grab those funds, so they can intercept the money coming from, say, the IRS to you, and take the money that's owed to your ex. That's another thing that they can do. They can suspend your driver's license, which would cause you a great inconvenience. I always find it ironic that they would suspend your driver's license when you owe money, because you probably need your license to drive to work to earn the money to pay your ex back. But there you have it. The court does have the ability to suspend your driver's license for lack of alimony payments. There could be a judgment and interest that's added. So not only would the judge say, look, you're behind $5,000 in alimony. Not only do I want the $5,000, I want you to pay interest on that $5,000 to your ex. So that's an additional punishment and an additional incentive to get you current and to keep you paying alimony going forward. And the worst thing probably that can happen to you is the judge can actually put you in jail. So you could be incarcerated for lack of alimony. So The incarceration is the most severe of all the sanctions that could happen. It's used as a sort of a last resort. The judge doesn't want to put you in jail necessarily because you're not paying your alimony. But if it looks like you have the ability to pay it and you're just refusing, and you're refusing for a long period of time, or if the amount of alimony that you owe is very large, those are the types of cases where a judge would more likely consider sending you to jail in order to get you to squeeze you to pay your alimony. And then we have clients that say, "Well, if I'm in jail, how am I supposed to pay the alimony? That doesn't make any sense." In practical terms, we see all the time that once somebody goes to jail, all of a sudden they reach out to whoever they might have. Maybe they have some money that they didn't tell anybody about. Somebody comes together to put the money together to get them out of jail because it's such a terrible situation. All of a sudden, the money is available and alimony is paid. So those are some of the sanctions that can happen to you as a result of not paying your alimony. Now, I mentioned before that there could be good reason why you're not paying alimony. So it may not be that you're not paying willfully. It's just that you're not able to pay. You have an inability to fulfill your financial obligations. Let's say you lose your job, for instance. That's a very common one. So you lose your job. The income that you had before, that was the alimony order was based on, is no longer there. How are you supposed to pay your alimony? So you cannot just stop paying it because you've lost your job or for any other reason. That order is in place until such time as a judge modifies the order. So that's what you have to do. If you lose your job, you face some sort of financial difficulty, you should immediately file a motion to modify the alimony payments. So what that does is that gives you a chance to go into court and to explain to the judge, my job shut down. There's nobody working there anymore. We all lost our jobs. I have no income. I can't pay alimony at this time. So the judge could hear that and may be sympathetic towards you. But it's much, much better than just simply not paying your alimony as you're supposed to. Consider this as well. Depending on how you get along with your ex, you may approach them and say, "Look, I lost my job. I know I owe you the alimony, but I just can't pay it now." So you come to an agreement with the other person to say, "All right, let's just suspend the payments until you can get back on your feet, until you get another job," or something like that. So you have an agreement, which is terrific. You still, from a legal point of view, even if the other person agrees to not take the alimony for a period of time, you're still legally obligated to do that. So you still need to go before the court. You let the judge know we have an agreement. So it's much more likely that a judge will, accept that position, especially if it's a short-term or a temporary matter. But you go in with an agreement, the judge is more likely to grant your modification. If you cannot come to an agreement, then file the motion to modify, have a hearing, present yourself before the court. You should always have a lawyer, but in any case, and what happens is that the good thing about that is once you file that modification motion, okay, it's filed, it gets date stamped when it goes to the court. Your hearing is not going to be for a while, depending on the court schedule. So let's say it's several weeks later. When you go into court, if the judge rules that you don't have to pay alimony because you're out of work, that will go back to the time that you filed your motion. So it's retroactive to that date. So you don't have to pay. If the judge is willing to do so, you don't have to pay the money from the date that the court received your motion until there's another modification, say when you get your job back or when you're back on your feet financially. So that's kind of Alimony 101 as far as what can happen to you. It is a very serious matter. It can cause you all kinds of financial trouble, at your home, and potentially you could go to jail for it until you can get things straightened out. So try to keep up on alimony. If you can't for some reason, go before the judge, explain to them what's going on, and they may be sympathetic and grant you a modification, either decreasing or suspending alimony payments, at least in the short term. As I say, at Afford Law, we do practice criminal and family law throughout Massachusetts. Our fees are based on a sliding scale, which is based on your income. That means that the less you make, the less you have to pay. Please feel free to visit us at affordlaw.org and feel free to book a free virtual appointment with me. I'd be happy to answer any questions you might have about criminal law or family law matters in Massachusetts. Because at Afford Law, we're making justice affordable. Thank you.